My dear brothers and sisters, today I would like to share my views about the recent instance of filing cases against the cartoonists and also social media postings and other cases under the title Crushing Dissent, Declining Democracy, Drifting Judiciary, Defining Movement to Reclaim Our Constitution. My friends, when cartoons are crimes, tweets and plays lead to jail, it is not a democracy. It is a dictatorship with a smile. In any true democracy, freedom of speech, expression, and dissent in different forms is the essence of democracy and the cornerstone of civil life. Enshrined in Article 19, Clause 1, Subclause A of the Indian Constitution, it includes the right to criticize those in power, to express dissent, and to do so through satire, cartoons, poetry, comedy plays, videos, or the digital commentary. Historically, India embraced dissent with dignity and proudly upheld this principle. The legendary cartoonist R.K. Lakshman routinely lampooned the prime ministers like Pandit Jawaharlal Nehru, Indira Gandhi, and other leaders regularly through his caricatures. Yet, these leaders had the political maturity to take it lightly and laugh at cartoons and take criticism in their stride. They never retaliated or filed cases. Dissent was not seen as a crime, it was a part of the democratic process. But today, that democratic culture is shattered. A cartoon may lead to FIR, a tweet can spark police action. Under RSS-led Modi regime, dissent increasingly treated as a sedition. YouTubers and comedians like Kunal Kamra face threats and police action. Students, journalists, and civil society activists are targeted with multiple FIRs, EAPA cases, and incarceration in jail or relentless harassment. What is more alarming and troubling is the role of higher judiciary in the prevailing environment. The higher judiciary, particularly the Honorable Supreme Court, with due respect to them, which is expected to be the ultimate guardian of the fundamental rights and protect the Constitution, freedom of speech, expression, and dissent, in recent years, sending wrong and conflicting signals or even differential to the executive or the central government. Take, for example, in recent Supreme Court observations within a span of 2 days, that is from 14th and 15th July 2025, the benches of Honorable Justice B.V. Nagaratna and Justice K.V. Vishwanathan, Honorable Justice Subhanshu Dhulia and Justice Arvind Kumar and Justice Suryakant and Justice Joya Malia Bagchi expressed concern over increasing misuse of right to freedom of expression while dealing with the separate matters relating to social media posts, comedy contents, and allegedly the derogatory cartoons, cases involving the cartoonist Hemant Malviya, YouTubers, cases involving Kolkata-based Wajahat Khan, YouTubers like Ranveer Allahabadia and Ashish Chanchalani, and cartoonist Hemant Malviya. The court indicated the need for guidelines to be issued for citizens while granting relief to the respective petitioners in those cases. The court further said that such guidelines must align with the constitutional principles and reflect both freedom and responsibility. The court even invited suggestions from all the stakeholders, including the bar, and wanted to test a framework that balances freedom and duty, but at the same time cautioned that any guidelines the court consider should not be misused by anyone. But these observations made by different benches of the Honorable Supreme Court depart sharply from the recent rulings of other benches of the Honorable Supreme Court, upholding the freedom of speech and expression. In March 2025, the bench of Honorable Justice Abhay Oka and Justice Ujjal Bhuyan quashed FIR against a Congress MP for posting a poem on Instagram. The court said that they are bound to uphold the fundamental rights even when they may not like the content of the posting. Further, the court said that the law enforcement must evaluate the speech not from the viewpoint of the insecure or tolerant minds, but from the perspective of strong and reasonable citizen. On April 18, 2025, the same bench set aside the Punjab and Haryana High Court order that had imposed a cost of rupees 10 lakhs each on Vishal Dadlani and Tehsin Poonwala, even after quashing FIR against them, and said that the function of the court is not to do moral policing. So in this confusion, come a stark warning from a senior Supreme Court advocate, Sri Dushyant Dave, who said that the successive Chief Justices under Modi government have compromised and that the judiciary has become the biggest reason for the collapse of rule of law and institution. This is not the casual remark. It reflects the growing disillusionment even within the legal system. Meanwhile, it is to be noted, my friends, that the Modi government created Sahayog portal, SAHYOG portal under Section 79, Class 2, Subclass B of Information Technology Act, that is IT Act, designed to manage the takedown request with the which demand due process before content in social media platforms like X, formerly Twitter, bypassing the safeguards under Section 69 of Information of Technology Act, IT Act. So, the X, formerly Twitter, challenged the creation of a Sahyog portal in Karnataka High Court, and the central government filed a lengthy affidavit defending its move, which reveals its intention to curb the right to freedom of expression. So also the Maharashtra government passed Maharashtra Public Security Bill in the Assembly on 10th July 2024 to criminalize a certain kind of thought and ideology. This endangers India as an open society, and the possibility of its misuse is apparent. It portends danger to freedom and democracy. The idea that the thought and speech, however unpalatable they might be to the ruling establishment, should be policed, poses a grave danger for India as an open society, opined the National English Daily, The Hindu, in its editorial dated 24th July 2025. Under the circumstances, now imagine the same government which is already bypassing legal safeguards, diluting the constitution and weakening the democracy, if invited and given power to frame guidelines to regulate the right to freedom of speech and expression. This would amount to handing a sword to the one who is already attacking and suppressing the freedom of expression and dissent. So let us be very clear. The guidelines to regulate this right of freedom of expression, speech and dissent, if not meant to protect the society, they will become tools to silence it. When the executive or the government overreaches and when the judiciary hesitates, what remains of democratic republic and the constitution of this world's largest democracy? The higher judiciary must rise again to its constitutional mandate. It is not the spectator or a silent accomplice, but it should act as a guardian of the constitution. India today facing a defining moment. Either we reclaim our constitution and reassert the right to freedom of expression, speech and dissent, or we slide further into authoritarian, majoritarian, autocratic rule wrapped in legal language. However, we must take note of the observation, and the citizens also must be aware of what they are speaking and what they are posting and what they are caricating about the individuals. It should not be an offensive. It should be a reasonable, giving some meaning to the with regard to their actions, their illegal actions or unconstitutional things. So opposing a particular person is not an offense, but at the same time we must also be on guard. The citizens must also be on guard while posting the messages or making cartoons, etc. So that this kind of guidelines, under the guise of guidelines proposed by the Honorable Supreme Court bench, the government may not suppress our democratic right of fundamental right of freedom of expression, speech and dissent. Take care of the Constitution, and we must awake and arise to protect the Constitution. Thank you. Jai Constitution, Jai Bhim, Jai Bharat.